Inside a modern e-commerce fulfillment center, the sheer scale of the operation reveals a shift in the retail paradigm. These platforms no longer simply host third-party sellers. They leverage their own distribution algorithms and consumer data to launch high-margin private labels. When introducing these in-house products, many corporate giants rely on a specific legal playbook known as the housemark strategy. They append their globally recognized parent brand to a new product name, assuming this corporate association provides an automatic shield against trademark claims. The logic assumes that because the parent brand is so prominent in the marketplace, it's impossible for a consumer to be confused about a product's origin, regardless of the sub-brand's specific name. This creates a recurring problem. Because they believe the parent brand acts as a total differentiator, platforms frequently adopt sub-brands that look or sound like derivative versions of legacy manufacturers. Relying on corporate scale to dictate legal distinction is more than a gamble. It's a strategic vulnerability that leaves the platform exposed. In 2017, the Indian e-commerce giant Flipkart launched a private label for electrical appliances under the brand name MarQ. This launch placed them in the direct path of Marc Enterprises, a legacy manufacturer that had been selling allied electrical goods for decades. The resulting dispute reached the High Court of Delhi, testing whether a platform's market presence could indeed override traditional trademark protections. The court's answer was definitive. It granted and affirmed an interim injunction against the e-commerce giant, forcing them to stop using the mark. The ruling clarified the legal hierarchy. A massive distribution network provides no exemption from the established laws of trademark priority. The court first looked at the timeline of use. Marc Enterprises demonstrated continuous use of their brand name since 1981, with a formal registration secured in 1984. Their business was built over decades, establishing a physical presence in the traditional appliance market long before the rise of digital marketplaces. Flipkart, by contrast, only adopted MarQ in 2017 to sell a similar range of electronic products. To evaluate the conflict, the court applied the metric of identical trade channels. This test determines if products, even if sold in different ways, ultimately compete for the same customers. Even though Flipkart is a digital platform and MarQ is a legacy retailer, their target demographic for televisions and washing machines is essentially the same, leading to a direct competitive collision. When the products and the customers overlap this closely, the date of first use becomes the absolute axis of a legal defense. In analyzing the brands themselves, MarQ versus MarQ, the court followed a framework known as the anti-dissection rule. It is often tempting in trademark law to focus on minor spelling variations. To a designer or a lawyer, the difference between a C and a Q might seem significant. Flipkart's defense rested on these visual and structural differences, arguing that the suffixes were distinct enough to prevent confusion. However, the anti-dissection rule prohibits breaking a mark into component parts. A brand must be evaluated as an indivisible composite whole, not dissected to find minute variations. The law uses the standard of imperfect recollection. Since an average consumer primarily processes how a brand sounds, the phonetic identity of these two names makes them functionally indistinguishable in the market. Holistic impression dictates the boundaries of infringement. You cannot escape liability through micro-edits to the spelling. Flipkart's ultimate defense was the claim that branding the goods as Flipkart MarQ eliminated any risk of confusion. They argued that the Flipkart name is so ubiquitous across India that it acts as an absolute differentiator, separating them from any legacy manufacturer. The court found that this protective umbrella dissolved under scrutiny. It noted that Flipkart used its housemark so inconspicuously or inconsistently that it failed to actually distinguish its goods from marks. The ruling made it clear, the presence of a corporate housemark does not legally sanitize a sub-brand that is inherently deceptive. Even a dominant parent brand does not grant a company a license to infringe upon prior registered trademarks. Sub-brands must be able to stand on their own as distinct and defensible identities, regardless of the parent company's size. While the original injunction was issued in 2018, the case continued through a lengthy appellate process. During this window, Flipkart successfully registered MarQ's Flipkart MarQ and MarQ by Flipkart in 2020 and 2021. They then invoked Order XLI Rule 27 of the Civil Procedure Code, which allows an appellate court to consider supervening statutory events that happened after the original trial. These registrations created a conflict with the original injunction, as Sections 28 and 31 of the Trademarks Act confer exclusive rights to the owner of a registered mark. To achieve complete justice, the court admitted these new registrations into the record, but it penalized Flipkart with a 2 lakh rupee cost for the significant delay in bringing them forward. It is a reminder that appellate strategy must account for evolving statutory rights as they happen, not just the facts as they existed at the start of the case. The operational lesson for corporate strategists is that in-house labels require the same rigorous intellectual property clearance as any independent brand. This legal reality sits against a backdrop where e-commerce platforms are rapidly expanding their footprint across India, pushing further into every consumer category. As these platforms prepare for future IPOs, their focus on high-margin private labels will only intensify. The Marc v. Marc case acts as a vital economic safeguard, ensuring that algorithmic dominance doesn't allow platforms to simply roll over the established rights of legacy manufacturers. Legacy enterprises retain the power to defend their market share, provided they have fortified their brands through registration and prior use. Commercial scale does not override statutory priority. In the modern platform economy, intellectual property remains the ultimate equalizer.